G'day, I'm Michael Tesoro, and this is the cheat sheet for June 2025. And for those who might not have seen this before, what it is a summary of all the ACCC developments in June, primarily all the media releases issued by the organisation. The thing I mentioned this month is there was a huge number of press releases in June, like a lot of different matters, primarily in the enforcement area. So it's going to take a little bit longer than usual to get through them. Okay. Bit of background about myself. I'm a competition and consumer lawyer, and I've been running my own practice to Sale Legal Consulting for the last 18 years. And I help companies and individuals with competition and consumer law matters. Also do some expert consultancy work with various legal publishers on competition and consumer law, and have a part-time role with NCAT, New South Wales Civil Administrative Tribunal. And in that role, I get the chance to adjudicate on consumer law matters, as amongst other things. Prior to that, I worked at ACCC for 15 years, and I guess relevantly, I was Director of Enforcement and Director in charge of Sydney Mergers Assets Sales Branch. Outline is it's quite long. There's a couple of court matters, a lot of enforcement matters, one merger, some scam announcements. The product safety priorities were announced by the ACCC in June. There's some authorisations, some inquiries, and three other matters. The court case that came out was a decision in ACCC and Emma Sleep. And here the ACCC sued Emma Sleep, the German company, the Australian company, and another entity, Betseat, Southeast Asia. So what's happened here, there's obviously been some negotiations and mediation probably, and two of the entities have admitted breaching the relevant law, the Australian consumer law, in relation to the sale price of mattresses, bed frames, pillows, and accessories. The one that didn't admit to anything is the German companies, Emma Sleep GmbH. So they've agreed on that, and effectively what it related to was the advertisement of 74 products online between 2020 and 2023, and they showed the traditional ways of operating, strike-through prices, percentage discounts, savings, all the rest of it. And of these 74 products, it's been acknowledged that 58 of them had not previously been sold at the strike-through price or a price equivalent to that price. So effectively, they made up the higher price. And the remaining 16 products had almost never been sold at the strike-through price. So rarely were they sold at that higher price. So the companies have admitted they breached the law. There was also some admissions in relation to that the sale prices would be available for a limited period of time when that wasn't the case. So when apparently the period expired for the prices to be low, they didn't actually go up. So this is pretty bad conduct. It's pretty elementary to get this right. So the parties have agreed that there's liability, but they haven't agreed on a penalty. So it'll go back to a penalty hearing later in the year, and it'll be interesting to see what penalties determined. The other big case was actually an announcement that ACCC was commencing proceedings against Optus in relation to the sale of various telecommunications goods, and it was a done deal. There'd been agreement about the amount of penalty to pay, so $100 million, so it's a huge amount. This follows the Telstra case a couple of years ago where they engaged in pretty well the same conduct and paid a penalty of $50 million, which I thought at the time was very low given the conduct, severely unconscionable conduct against very vulnerable consumers. So Optus has agreed to pay $100 million, and effectively it's the same scenario. Customers were sold products that they did not want, did not need, could not use, could not afford, and in some cases they were pursued for the debts after they signed up to it. And the common characteristic of a lot of these consumers is, they were vulnerable consumers, special disadvantages, mental disability, diminished cognitive ability, learning difficulties, financially dependent, unemployed, limited financial literacy, a lot of Indigenous people from regional remote communities. So picking on very vulnerable people, it's just terrible how this happens. And I guess what happened, they had a number of franchises which were engaging in very dodgy conduct. So here you had 400 consumers, which is probably about twice as many as were involved in the Telstra case, 16 different stores, and it occurred from 2019 to 23, so 4 years. So this is very extensive conduct by any measure. And so they engaged in a lot of questionable conduct, putting undue pressure on consumers. Somebody comes in, wants to buy something simple, then they force them or pressure them to buy more. extra things. In one case, actually, somebody was just standing outside the store and they sort of pressured him to come in, and they sold all this stuff. Failing to explain relevant terms to the consumers, selling them, Optus plans to areas where they lived which weren't covered by the Optus network. So lots of problems. And actually, when you read the press release in some detail, there's some strong implications of a bit of fraud going on. So in order to get some of these guys across the line, particularly those without a lot of money, had to manipulate the credit information so they looked like they could actually pay. So there's some very serious conduct going on here. The other very serious one was Bupa, and this is a done deal. So ACCC has been talking to Bupa for a while, and they instituted proceedings on the 30th of June, so towards the end of the month, basically alleging that Bupa had engaged in unconscionable conduct, and this relates to members' entitlement to private health insurance benefits. So basically there were thousands of consumers over a period of 5 years who were sort of told that they weren't covered for procedures that they were covered for. So that's it's fraudulent probably, but clearly unconscionable. People who've got medical problems are being told that they're not entitled to private health insurance benefits for their entire claim. Now that might result in them paying more for the procedure out of their own pocket, or maybe electing not to have it. If they don't have the money, they might say, well, I can't afford to do that. And all the time, these people were covered. And it related to the assessment of 388 mixed coverage claims. So they're going to jointly ask the court for a penalty of $35 million, and they've actually already started paying compensation to 4,100 claimants, or claim in relation to 4,100 claims, $14.3 million. This is very, very concerning conduct, and it's quite a big provider engaging in such unconscionable conduct. The thing that's concerning here is you don't see any individuals being held accountable for the conduct. You think that somebody must have been behind this strategy to deny these claims. Then you got some smaller cases. Rebello, which is an online marketplace for new and refurbished electronics, and they made some misrepresentations about consumer guarantee rights. So they were hit with 3 infringement notices, so paid about $60,000. And it's the sort of the classic one, saying that people have 14 days to basically get refunds for damaged goods and return damaged goods and so on. But that's clearly misrepresentation. Then this is a strange one. There's 3 companies in the same press release. I must admit, when I was at ACCC, we never did that. That's 3 press releases we can get out. So they had so much on, they're actually putting different companies in the same press release. I guess it makes sense here because they're all related to the same thing. ACCC did a sweep around the Black Friday sales and discovered a few companies not doing the right thing, and so they hit each of these companies with an infringement notice. They had Michael Hill Jewelers, Global Retail, which is probably better known as My House, and then the Hair House Warehouse Online, which is called Hair House. So effectively they were just saying things about the sales that weren't accurate. And you've got the pictures here. This is the Michael Hill one, saying 25 off store-wide, and that wasn't accurate. It wasn't 25% off everything. Here you'll have the My House one. I think the 60% off RRP wasn't the problem. I think it was a 20% off, extra 20% off. There was quite a lot of exclusions there, and so you've got big writing, and then you've got very small writing down the bottom, and you've got some fine print disclaimers. So that's obviously problematic. And then you had Hair House, 20 to 50% site-wide. That's pretty clear. And then down the bottom you've got T&C Supply. So they're saying they're offering everything, and then there's lots of exclusions. I'm going to also say that 20 to 50% off, that's not very meaningful, is it really? You just decide on a number, really. But yeah, so all 3 companies made some pretty fundamental mistakes. They weren't hit very hard, one infringement notice, and the ACCC has got the message out. Jayco, I feel a bit sorry for Jayco because ACCC have been talking about the problems of the caravan industry for a long time. Jayco are the biggest manufacturer of these products, and it was just a matter of time before they got sued again. They got sued a couple of years ago, and they did pretty well in fending off a lot of the ACCC representations and claims. But here it's a different one. ACCC is alleging that they misrepresented the ability of their vehicles to go off-road. And so, as you can see, there's 3 brands: Outback, All Terrain, and Crosstrack. Now, I've got to say, Outback, maybe not 4-wheel drive, but All Terrain and Crosstrack, the names just suggest these caravans can go off-road. They can go 4-wheel driving terrain. And what the ACCC is saying is they're not designed for off-road or four-wheel drive use. So that's a pretty significant one. ACCC will obviously have to establish how they were designed and whether they could do it. And in the press release, they refer to a couple of images on the JCO websites. This is the one I chose, which shows somebody with a four-wheel drive taking a JCO caravan through a very, very high river. If you ask me, I don't think I risked that in a million years. It washed away, but it's either able to do this or it's not. It's likely to suffer, defects if somebody does actually think it can go off road and they take it off road. I guess it's also a bit of a safety issue. So it's not really designed for this. What's going to happen if it's, if you try to do this? It's just going to be somebody placed at risk. I don't know. But anyway, I think JK probably fight this case. They're probably saying maybe they're going to be arguing that the caravans are able and are designed to go off road. Because if that's not their case, they're going to lose. So that I'm assuming that's what they're going to have to argue. Mabel Technologies. So this is a company. It's an interesting company. It's sort of set up this platform where NDIS workers can sort of come onto the site, find clients. Clients can find providers of services, and it sort of matches them all up. A very good idea, I think. It's a bit like some of the other platforms that you see matching up different people, Airtasker or somebody. So here the problem was that they had various terms and conditions, and the ACCC was concerned they were unfair. And it seems the company has agreed that their terms were unfair and agreed to amend them. But that's a good outcome for Mabel because obviously there's no litigation, there's no penalty, it's just an agreement to amend the terms. And a couple of examples of the terms. So a support worker leaves a Mabel platform, they'll be liable to pay a penalty if within 12 months of leaving they continue caring for a person they got through the platform. So that sounds unfair because, you've got the consumer deciding they want to stick with this particular support worker. Why should the support worker be punished for being, the preferred supplier of these services? So that seems unfair. And then the client services log. So this is an invoice that's sent out to the client about the work that's been done, and it had a term that if the client didn't dispute it within 24 hours, it would be automatically deemed to be appropriate bill and should be paid. And so I think the problem with that is it's a pretty short time frame for anyone, 24 hours to sort of check a claim that might have quite a lot of items on it, make sure it's all properly done. But I think it might be particularly short period of time for some of the clients who have, significant health issues. So Mabel agreed to get rid of those two terms and a few other terms, but it's a sensible outcome. You quickly get it sorted out. Mabel entered into 87B undertaking has to introduce a compliance program. Diamond Energy. A lot of these retailers are getting nailed for breaching the electricity retail code. It's not rocket science. I don't quite know how they keep getting in trouble, but on 18th of June, Diamond paid 3 infringement notices, so almost $50,000 for breaching the electricity code. They relate to 3 specific consumers, but realistically, there were thousands of consumers in the same boat. Obviously, you're on sort of 12,000 infringement notices, but here you've got Diamond admitting that it sent communications to over 12,000 consumers which failed to include the required pricing information on the code and notifying other required information in relation to electricity plan. So some pretty fundamental breaches of the retail code. Not the hardest outcome for them, but you're just wondering why so many electricity retailers are making mistakes on this code, like even some of the real big players. CDR, this hasn't had a lot of activity recently, the consumer data right, very important amendment or very important innovation that's really going to enhance a lot of competition in a lot of industries. It's been pulled back a bit by the Albanese government. I don't know why. They haven't been pushing ahead quite as hard with it as the previous government. But here you've got NAB being caught out for failing to comply with their obligations, served with 4 infringement notices for breaching the CDR rules. Big penalty, $751,000. And what they did was you got the CDR accredited providers asking for information on behalf of consumers, so give us info, and it's alleged that NAB failed to disclose or accurately disclose credit limit data, so they're not providing the correct information, which obviously, if you're not providing the correct information, there's no way the person's going to be able to switch their provider. Dendy Cinema, I'm a bit sad about this one, I like Dendy, but it's not the worst outcome of all times. It's drip pricing. Haven't been many of these cases recently. The classic drip pricing was many years ago. Airlines, they'd add on all these extra items. You want a muffin, that's an extra $5, something like that. And then you had the car rental companies that, classic drip pricing. So you'd see the headline number, and you think, wow, that's a good price. And then by the time you got to the end of the process, you'd be paying twice as much. So it's pretty well stamped it out. I don't think a lot of companies aren't doing it. The key here is if it's an unavoidable cost that you're aware of, then you've got to say what it is. So if it's here, a ticket booking fee, you've got to say what it is because you know what it is. You should tell the consumer. If it's something you don't know, say freight costs to remote location, you don't have to include it. So Dendy got hit with one infringement notice, which is not terrible, and they've just got to change the systems to show the full price at the earliest opportunity. This is a big case, Australian Gas Networks Limited, and this is based on this Environmental Defender Office complaint, which went to the ACCC. They've actually got it on this website. It's a fantastic complaint letter, very lengthy, but it goes through all the details, does a really good job explaining the law. And the ACCC's obviously, got that letter and said, hey, this looks good, and commenced proceedings against AGN. And what it relates to is this Love Gas TV and digital advertising campaign. And what the ACCC has alleged is that they're telling consumers that effectively the gas which they're selling to households will be renewable within a generation. So that's the representation. And the ACCC is also alleging that's a future representation. So they're making a representation about a future event. And they're saying that's not true. Like there's no evidence, scientific evidence to back it up. So it's a big case, significant case, and the way AGN's been talking, they're going to fight it. You'd think that they're going to have to fight it on the first ground, that we didn't actually represent that at all. What we're saying is, gas is good and it's going to be renewable. We didn't say within a generation. You think that that's the ground that they're going to fight it on, because I don't think if they fight on the second ground, they're going to win, because I don't think the evidence is out there that the gas supplied to households is going to be renewable in a generation. I think they'd lose on that. Another one, two companies in the same press release. It's just how much work the ACCC is doing. They're just doubling up. Again, these were very similar alleged contraventions. Cash converters and MTA, mobile travel agents, are big companies. Cash converters got a lot of company-owned stores, a lot of franchisees, and mobile travel agents has heaps of franchisees. And what they failed to do was to update or confirm franchisor information in the Franchise Disclosure Register. So this disclosure register that got brought in to provide franchisees with information about different franchisors. Not a huge amount of information. It's not. I don't think it's super helpful, but there's some basic obligations. You've got to put certain information on there, and these two companies failed to do that. So as a result, they both got hit with an infringement notice, 16,500. The next one is the only merger for the month, Allianz and Royal Automobile Association of South Australia. And there've been a lot of these state-based automobile associations being bought out by the big insurers. And I guess the key thing here is that, the market's very, very big. I think sometimes people look at these markets as state-based markets, but I don't really think they are. They're probably national, in which case even companies like Allianz are going to be very small market shares. And then when you look at the targets, they're going to be even smaller. So here the ACCC announced 12th of June that it was not going to oppose it. They found that in relation to particular insurance they provide, which is home and contents insurance and motor insurance products, it's not going to lessen competition. That's because on a national basis, at least, it's tiny market shares of the target. Even on a state basis, you'd be thinking probably the market shares aren't huge. A lot of competitors can come into the market. A lot of other insurers can come into the market fairly easily if they've already got an insurance license. The other thing that's been apparent in these cases is that ACCC, when it's looked at it, sort of formed a view that the targets weren't necessarily very sustainable businesses. And that's because it's getting very expensive to get coverage. And so here they're saying RAAI would be facing specific challenges that would make it less competitive. So it's having trouble getting reinsurance, which suggests its days are numbered probably. It's not quite failing firm, but they're struggling to compete as markets get tight. Scams. So two interesting scam announcements. The first was 2nd of June. The National Anti-Scam Centre called on businesses to pick up their act in terms of reducing the level of scams that are going on in Australia. I think Australian business hasn't been really that active in this area, which is very problematic, and it needs to pick up its act. I guess here you've got the biggest increase in the recent times has been phishing scams. So this is scams impersonating various entities, government agencies, financial institutions. The key factor here, it's gone from 4.6 million last year to 13.7 this year. So it's tripled in a year. So that's a very big concern. Had some scam trends in addition to the phishing scam. Investment scams, very significant. As you can see, the money's a lot higher here, $59 million. Now, even though it's going down a bit, it's a big, big area of scams. Scams through social media have increased considerably, 50% increase in people reporting financial losses through social media. Also big numbers, $23 million through that particular thing. I guess known this for a while, older Australians, so it's not me yet, 65 or over, reporting the highest losses. So when older people get scammed, they tend to lose a lot more money, maybe because they've got a lot more money, I don't know. And then the other thing here, interesting thing here, younger Australians, which I think must be a reference to 25 to 34, um, were most likely to report having lost money. And then you've got the other category, 35 to 44, which probably, that would be younger Australians, would it? Younger than the older Australians, I guess. But younger people are just as susceptible to these particular scams as older people. They just don't lose as much money. ACCC warning. This was really interesting. It's actually it's not 219 June. I think it might be 21st of June. The National Anti-Scam Centre issued a warning that apparently people are trying to use the ACCC credentials to scam people, which is pretty cheeky stuff, to actually use the regulator who's charged with combating scams as the scam vehicle. So here they've been using their phone numbers, they've been using various addresses. So the ACCC's been aware that people have been using the publicly available ACCC phone numbers. There've also been people claiming to be representatives of the ACCC sort of requesting sensitive information over the phone. So this is a big problem. Actually, when I was at the ACCC, this also happened. Some people, we became aware of some people going around claiming to be ACCC officers trying to get confidential information out of businesses. So we never got to the bottom of it, but that was in the old days when it was all face-to-face scamming. Nowadays, it's all over the internet. ACCC announced its product safety priorities, 27th of June 2025, and did a big speech. This is really good that they're being clear about what they're going to be focusing on. It's only 5 areas, but they're big, big areas. So even though they have 30 areas like the enforcement compliance priorities, these are big areas. It'll be a lot of work. Addressing unsafe products in the digital economy, that's huge. So many online sellers of products, so many products that don't comply with safety standards. It's a huge thing, and I don't know quite how they're going to combat that. Consumer and product safety issues impacting young children. That's also a huge category. Obviously, they'll probably drill down on a couple of issues like button batteries, toppling furniture, but there are a large number of standards relating to young children. Lithium-ion battery safety. So that's a developing, or it's developed, but it's continuing to develop technology, and they've got to be looking at the safety issues around that. Updating mandatory standards is a new focus on looking at what's overseas standards, and maybe incorporating them into Australia. It's going to be a big chunk of work for the ACCC. And then improving product safety data to identify safety risks. Obviously, taking a more proactive approach to reducing product safety risks. A couple of authorisations. Steelline members, they sell roofing products, and they got approval to jointly sell and advertise the products, and also collectively bargain with their suppliers. So that's obviously going to be transaction cost savings. If you can do things jointly, it's not going to lessen competition. Battery stewardship scheme. What's happened here is this scheme's been around for ages, but I guess it was very much focused on the old battery types, and you've got new lithium batteries, taking over the markets, and big electricity batteries associated with solar panels. So there's a need to just sort of look at the market, work out a new system, and then put it to the ACCC. So there's interim authorisation being granted to allow the Rural Council to have a chat with other participants in the market, work out a new levy arrangements which involve eco-modulated, I guess, batteries and other battery types. Cash in transit, this is a bit of a disaster. Armaguard decided to acquire its competitor, Prosegur, a Spanish company, a few years ago, and ACCC grudgingly agreed to it and said all this sort of stuff about various undertakings it needed to do and reporting. No sooner had it happened than Armaguard said, "We're going to go broke. We can't sustain the business." So it was pretty clever by Armaguard, I thought. And then since then, there have been desperate attempts to try and keep the industry going because we need cash. And so if there's nobody who can carry around the place, there's going to be a lot of problems in industry. So here, the Australian Banking Association, the major people who need the service, major banks, major retailers, supermarkets, Australia Post, have been talking about how to keep Armaguard from going under. And it's pretty bizarre because Armaguard's owned by Lindsay Fox, who's a pretty rich individual. But he's not too proud to go to his customers and ask for a handout, and that's what he's got. He's got the major banks and retailers are going to provide financial support to Armaguard to keep him operating. Discuss and agree different measures to make the business sustainable going forward, efficiency measures. But even though they can talk about pricing, they're not allowed to actually implement it. So they're going to talk about pricing. They've got one of the big four accounting firms in there to try and work out the pricing options and then effectively work out a pricing mechanism, but then have to come back to the ACCC, pay the ACCC some more money and get that approved. Inquiries and consultations, there were the first three, fuel, and this looks at petrol and diesel, and it found that the petrol prices had gone up. This is due to the fact we got a weak exchange rate with the USD, so that makes sense that the price would go up. And diesel price also went up, and that was due to international demand factors. No surprises there. NBN Co. This is a first accounting separation report, and what this is all about is that obviously NBN has two different types of services: monopoly core services and competitive services. And what's got to make sure happens is that they don't sort of subsidise their competitive services with their monopoly services. So they've got to make sure the proper cost allocation between those two things. And so what they do is they prepare a report, give the ACCC. ACCC says everything's fine. So the report won't be published because obviously you're going to assume it's very confidential information. So it's a funny report where they prepare it, give it to ACCC. ACCC satisfies itself that nothing funny is going on, and that's where it ends. Australia Post has been around for a long time, hasn't it? I didn't quite understand this was such a long process. Australia Post can't increase the price of its reserve services without getting approval from the ACCC, but it's not really approval. Like the ACCC looks at it, works out if it's reasonable, says, yeah, we think it's okay, but then the minister has to make the final decision. So from an economic point of view, it's justified. Like, they're not making money, they're losing money hand over fist, they're going to continue losing money, they need to stem that losses, and so they put prices up. Ultimately, the minister will make a decision, but I guess the ACCC says they're not going to object to it, then the minister's decision is pretty easy. Then the Measuring Broadband Australia report, and this is looking at obviously Starlink and NBN and the satellite networks. And effectively, it's looking at how they're performing. And I think it's fair to say, probably only a year ago, Starlink was way ahead of NBN. So in the last 12 months, I think they've picked up their act and they're quite competitive now with Starlink, which is good. So there's two competitive, providers of these satellite services, particularly people outside, outside regional metropolitan areas. So as you can see, Starlink service recorded an average busy hour download speed of 170 megabits per second, and then you've got NBN, something between 1662 and 283. So they're very fast, and now there's some good competition between those two providers. ACCC issued its final digital platform services inquiry report. This is sort of a summary of everything they've done up to now. It's just fantastic work by the ACCC. I think they've done tremendous work. Just really sophisticated, in-depth, really understanding the markets, world-leading work for many years now, and they've culminated in the report. The big thing, excuse me, the big thing now is to actually implement some changes. to regulate the digital platforms. And as you can see, the ACCC believes a continued risk of widespread harms to Australian consumers and small businesses from the way the digital platforms operate. Consumers continue to face unfair trading practices, manipulative design practices, and so there's a lot of dark patterns being used by digital platforms to try and get consumers to make decisions which aren't the best decisions for them, or just to stay with the incumbent providers rather than switching to a new provider. And I think the key thing here is you look around the world, in almost every country they've been sued. Almost every OECD nation, digital platforms have been sued, and the regulators are winning the cases. So there's no suggestion that this law isn't needed. Like, this law clearly is needed. Digital platforms have huge market power. They're using the market power to entrench their positions, to keep others out of the market. They're causing a lot of harm, and so we need laws to regulate them. So that, I think, is beyond any really serious debate that these laws are needed. The ACCC has proposed industry codes, so work's got to get started really on that to bring these codes in. Unfair trading practices laws are very necessary to deal with some of these dark patterns. And there'll be a lot of work for the ACCC to get those industry codes developed, consult with stakeholders, and get them brought into law. The gas inquiry report is also a very depressing reading. The gas supply outlook has deteriorated yet again. It looks like there'll be a shortfall in fourth quarter of 2025 and into 2026. And it looks like the risk is the LNG produced in Queensland. If they export all the uncontracted gas, there simply won't be enough gas for Australian consumers, particularly in the southern states. And it was interesting down the bottom there were sufficient gas reserves and resources to meet projected domestic demand. So there is enough gas in the ground to deal with this problem. It's not coming out quickly enough. And I can't help thinking that maybe the gas industry's got this agenda where they sort of create this scenario of panic and forces governments to just, approve lots of gas licenses and agree to all this fracking and just allow basically all these different ways of getting gas out of the ground. Because really, it makes sense if you want to put pressure on the government to just sign off on all these gas development proposals. This is the best way to do it. It is a risky game because ultimately the government might seek to regulate the industry more. The other designated complaint, so the Australian Consumer Law Action Centre issued a designated complaint. They're one of the three organisations that can do that. And the ACCC has announced it's kicking off its inquiry into this issue. It is in relation to unsolicited selling, lead generation, door-to-door sales and cold calling. So it's a big area of activity. Some of it's dropped off a bit. I think door-to-door and cold calling's dropped off quite a bit in recent years. But there's a lot of unsolicited selling, I guess, in shopping centres, stuff like that. And lead generation's a big business, companies generating leads and selling them off to other companies. So this is going to be interesting how the ACCC deals with this. This conduct, if when done inappropriately, is against the law. So whether the ACCC is going to take a number of enforcement actions against some bad players, or whether they're going to think of some other approach, maybe some sort of code, I don't know. But it'll be interesting to see how it pans out. The National Consumer Congress happened. I've never actually been to one of those. I don't know. I've got to try and get on the invite list maybe. But on 27th of June, Jenny Cass-Gottlieb provided the keynote address to the Congress, and she spoke about product safety, so it's worth having a read of that. Finally, the Digital Platforms Regulators Forum. This was set up a few years ago because it was important to bring together all the key digital platform regulators. That's ACCC, ACMA, eSafety Commissioner and the Privacy Commissioner. And I guess what they're trying to say here is that even though it was sort of set up, there's a real need to maintain this forum going forward. So it should become a permanent forum. And I entirely agree with that. I think it makes perfect sense to do that. So commentary. Enforcement outcomes went through the roof in June, just so many. There's been a lot of criticism of the ACCC that hadn't been a lot of enforcement activity, particularly in Part 4, and I guess there wasn't really anything in Part 4 in June, but that's a huge amount of work. The thing I find a bit ironic is that, the Enforcement Commissioner, Liza Carver, left a few months ago. There's no new enforcement commissioner. There's not likely to be an enforcement commissioner anytime soon, and she's out of the picture. And suddenly enforcement outcomes have gone through the roof. So clearly, some of these would have been brewing along when she was there, like that Optus resolution and the Bupa one. But it doesn't seem the ACCC is suffering too badly not having an enforcement commissioner. They seem to be really ramping up their enforcement outcomes. Optus case, very significant case, $100 million has been agreed. Now, if they get a particular judge, like Judge Foster in the Volkswagen case, that penalty might be seen as too low, and it could up it. And realistically, if a judge sort of says, no, 100 million is not enough, should be 150, really Optus, I think that all they can do is really, take it on the chin, because if they fight that case, they're going to lose. There's no doubt they're going to lose. So it'd be interesting to see what happens there, depending on which judge gets it. Same with Bupa. If Bupa, the judge looks at that and says, no, $35 million for this, are you kidding? It should be 70. It's a few hundred. What they could do, they'll no point fighting the liability case because they'll lose that. I guess they could appeal if the judge does up the penalty, they could appeal that. Don't know whether they have a lot of luck, but really the key for the Optus and Bupa case is which judge gets it. There's some judges who would just look at the conduct, look at those penalties, and think they're just too low. Australian Gas Networks case is going to be a really interesting case. Does CMAGN are going to fight the case? It must be on the basis that they don't believe they conveyed the relevant representation, that gas would be renewable within a generation. And maybe they can succeed on that. But if they're trying to succeed on not future representation, my understanding of the science is they're going to lose on that. There's no way that they can point to any science that supports them there. And accordingly, they wouldn't have reasonable grounds for future representation. Product safety priorities, they're big ones, a lot of work in all of those, but it's important that they get spelled out and everybody knows what they're focusing on. But the challenges of dealing with particularly unsafe products sold through digital means is just going to be really hard to do. Digital platform's next step. I guess the ball now is definitely in the corner of the government. They've got to start actually bringing some laws to counter all this stuff. We're probably a bit late to the party. But I think maybe we'll be a bit more principled, a bit less knee-jerk than some other jurisdictions that sort of rush things in. But we need to do something fast because, there's no way the digital platforms are breaching the law in every other country in the world and not doing it here. They're engaging in the same conduct here. So we need to bring in these codes of conduct ASAP. I think we do need, unfair trading practices. As long as it really focuses in on dark patterns, then I think it's a good thing. Gas outlook is very depressing. It just seems like every time it looks like it's going to be no shortfall, things change and it looks like it's going to be a shortfall. And I'm just wondering whether the gas industry is playing a bit of a game here to try and force the government's hand to approve a lot of gas development projects, including fracking and all the rest of it. It just seems unusual that they wouldn't do more to try and get around possible more regulation, by becoming the party. So maybe there's another agenda going on there. There's no complaints. There's a couple out there. The first one's been kicked off. It'll be really interesting to see what happens next. So hopefully that's been helpful. There's been a huge amount of stuff in June. A lot of really interesting, enforcement outcomes. Consumer data rights, franchising, retail electricity code, you name it. ACCC very, very busy. It seems like they're clearing the decks almost. But I guess just reiterate that it doesn't seem having no enforcement commissioner has negatively impacted their enforcement outcomes. In actual fact, they seem to have improved dramatically. So if you have any questions about any of that, feel free to give us a call or drop me an email. Bye-bye.